Well, the Supreme Court is soon wrapping up hearing arguments on California's Prop 12 of the National Pork Producers Council and American Farm Bureau challenged the law, which bans the sale of pork from hogs that fail to meet the state's new production standards. Roger McEowen with the Washburn School of Law listened to the case as it was happening. And thanks, as always, for joining us. So give us your perspective. How do you feel this went today, for the ag industry?
Well, good to be with you, Suzanne. And it literally just ended a few moments ago. I would tell you this. When I heard the opening argument by the Producers Council and listened to the questioning by the justices, that did not go well at all. But then when the state of California, when their attorney took to the podium, it didn't go well for him either. So I think this survives, a motion to dismiss.
Yeah, I don't know if you need to take a drink or right now, but, I just want to talk specifically, what the ag industry argued, and how the state of California is countering. If both sides really are struggling, it seems, and what is the next step from what you saw today?
Well, I lost my voice for some reason.
It
kicks back. I think it kicks back to the Ninth Circuit. And the state of California is going to have to demonstrate why the route that it chose with Proposition 12 is the least burdensome approach on the market. And that seemed to be a theme of all of the justices. And in fact, Justice Thomas said, couldn't this be solved with national legislation? So I think the Dormant Commerce Clause issue is not a good argument. That's not going to go anywhere. But I think they're going to try to thread a needle here and say, maybe labeling is the answer. I heard that over and over. That seemed to come through. Isn't labeling the solution? Can't you just slap a label on these products and say, well, these pork products were produced in an inhumane manner that California doesn't like? And the answer was yes. Both sides said that. And I think that's what the court is looking at. And they said, well, isn't that less burdensome than requiring producers such as in Iowa to change their production practices? And that seems to be the indication as to where the court's leaning on this. So that's why I think this survives a motion to dismiss.
Wow. So you think it's going to come down to labeling and, how far along do you think we'll have to wait on this ruling if they decide to go with labeling?
Well, I think 2 years from now, you could see it back before the Supreme Court.
Wow. So it's going to take that much of time.
It could, unless the Congress comes in and says, this is how we do it.
Yeah. What happens, as far as, if it wasn't about labeling, talk about the effects of ag overall and the precedent that this does send and what that does mean for the ag industry.
Well, I wouldn't use the word precedent. We don't have anything yet, and this is not going to be a precedent simply because it's on a motion to dismiss. I did find it interesting that Justice Alito used an example that I used yesterday with Scott Shalady on Cowguide Clothes. And I said, and this goes to your question as to impact on what states could do. I said, you could have retaliation by another state. What if Iowa, some tree organization, conservation organization in Iowa says, well, we want a law that says we don't want to eat almonds that are produced, that are harvested by shaking the trees rather than hand-picked. Well, California produces 100% of the almonds. Iowa produces nothing. And so you could have a state retaliate that way. And that line of questioning, that specific example was used by Alito. And he changed it a little bit in terms of water production on the trees. But you could see that by various states retaliating based on what they don't produce, but they use products from other states that are produced in other states. And that seemed to be a theme across the justices, this retaliation and what would happen to the ag market as a whole with a whole bunch of products. Because you could think about, I think it was Justice Sotomayor that brought up logging. You could have it with apples. You could have it with potatoes. You could have it with all types of products. And so I think the court is really concerned about that. When you have a major player in the market, California produces 13% or consumes 13% of pork products, but doesn't grow any of it. Doing this, that requires a change in production practices in another state. But on the other hand, some of the justices were concerned that this is what California voters approved. So I still think there's enough to get past a motion to dismiss, and it goes back to the Ninth Circuit. I think the Supreme Court will give the Ninth Circuit some sort of guidance to give California to determine how they can do this, but do it within the law and uphold California's morals. And the court was also concerned about that, too.
Yeah, it's interesting, Roger. And again, just an overall, takeaway from all of that has transpired today. And I love your talk about the fact that states can really start to lay out their own laws. So, when you look at this overall, your thoughts?
Well, this has a lot of tentacles to it. This is important to energy generation, renewable fuel standards, renewable portfolio standards in the states. What can one state do in terms of requiring energy production in another state that is consumed in a different state? This has all types of tentacles. This is a very important case. I would be surprised after hearing the arguments today that the Supreme Court agrees with the Ninth Circuit and just dismisses the case. I don't think it's over by any means. Now, I thought it might have been over after the initial arguments, but not as this went on for 2 hours. I think they're going to provide some guidance to the Ninth Circuit, and this could eventually come back in a couple of years. But there are a lot of tentacles. This is a big one for agriculture to watch across many realms of agriculture.
Well, of course, all eyes will be on this, and we'll be watching for sure. Always appreciate your insight. Thank you so much, Roger. Roger McEowen with the Washburn School of Law. Again, appreciate your time this afternoon.